This video is especially recording from my colleagues, my brothers, who are appearing in the upcoming CISF LDCE exam. So in this lecture, we are taking up the articles of Constitution which are prescribed by the syllabus. In our syllabus, we have 4 articles: Article 19, Article 20, Article 90, 20, 21, 22 from the Constitution of India. So without wasting our time, we are simply go to our preamble and then jump up to Article 19, 20, 21, 22. So our preamble is reciting like that: We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, political, liberty of thought, expression, belief, faith, worship, equality of status, opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, the 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. So this is our preamble, and we are taking up the relevant article for this exam, that is Article 19, 20, 21, 22. So in part 3rd of our Constitution, our fundamental rights are mentioned from Article 18 to 22. The rights related to freedom of speech are mentioned. So this is our bare act of Constitution of India, and I am reciting those acts and try to convey the exact meaning for the exam purpose. So these are the articles which is mentioned: right to freedom. Article 19. All citizens shall have the right to freedom of speech and expression, to assemble peacefully without arms, to form associations or unions, to move freely throughout the territory of India, to reside and settle in any part of the territory of India. This is the first part of Article 19, which simply conveys about the freedom of speech and expression, peacefully assemble without arms and associations and unions, and move freely throughout the territory of India, to practice any profession or carry of any occupation, trade, and business. So next, nothing in subclause A of clause 1 shall affect the operation of any existing law or prevent the state from making any law in so far as such law imposes reasonable restriction on the exercise of the right conferred by the said subclause in the interest of the sovereignty and integrity of India, the security of the state, friendly relations with the foreign states, public order, decency, or morality, or in relation to contempt of court, defamation, or incitement to an offense. So in case of security of state, friendly relations, foreign states, public order, decency or morality, in relation to contempt of court, defamation, and incitement of offense. In next clause, nothing in subclause B of the said clause shall affect the operation of any existing law in so far as it imposes or prevent of state from making any law imposing the interest, sovereignty and integrity of India, public order, reasonable restriction on the exercise of the right conferred by the subclause. Nothing in subclause C of the said clause shall affect the operation of any existing law in so far as it imposes, prevent the state from making any law in the interest of sovereignty and integrity of India, public order, morality, reasonable restriction on exercise of right conferred by subclause. Nothing in subclause D and E of the said clause shall affect the operation of any existing law in so far as it imposes and prevent the state from making any law imposing reasonable restriction on the exercise of any rights conferred by the said subclause, either in the interest of the general public or for the protection of the interest of the scheduled tribes. Nothing in subclause G of the said clause shall affect the operation of any existing law in so far as it imposes or prevent the state from making any law imposing in the interest of the general public reasonable restriction on the exercise of the right conferred by the said subclause, and in particular nothing in the state's subclause shall affect the operation of any existing law in so far as it relates to or prevent the state from making any law relating to the professional and technical qualification necessary for practicing any profession by carrying on any occupation, trade, and business. This is very important to note that in subclause G, what is subclause G? Subclause G is to practice any profession and carry any occupation, trade, or businesses. So in subclause G, there are few exceptions, that is the professional or technical qualification necessary for practicing any profession or carrying on any occupation, trade, or business. The carrying on by the state or by a corporation owned or controlled by the state, or any trade, business, industry, or service, whether to the exclusion, complete or partial, of citizen or otherwise. Article 20. No person shall be convicted of any offense except for violation of a law in force at the time of the commission of the act, charged as an offense, nor be subjected to a penalty greater than that which might have been inflicted under the law in force at the time of the commission of the offense. No offense shall be prosecuted and punished for the same offense more than twice. No person accused of any offense shall be compelled to be a witness against himself. So this is very important act to remember, that in the first act they are simply tell us that you can't provide any person the penalty greater than the punishment when the offense is committed. And in second clause they are telling us and preventing the double jeopardy in the justice system, that you can't punish a person twice for the same offense. And in the third clause, no person accused of any offense shall be compelled to be a witness against it himself. Article 21. No person shall be deprived of his life or personal liberty except according to procedure established by law. 21A. The state shall provide free and compulsory education to all children of the age 6 to 14 years. Sorry, this pen is using a highlighter to highlight this. And age of 6 to 14 years in such a manner as the state may be by law determine. And Article 22. The first clause is no person who is arrested shall be detained in custody without being informed as soon as may be of the grounds of such arrest, nor shall he be denied the right of consult and to be defended by a legal practitioner of his choice. So it simply told us that the person who is arrested is being informed about the grounds for which he is arrested, and the right to consult must be provided to them. And the second clause is every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours. Every person who is arrested shall be produced nearest magistrate within 24 hours. And the journey from the palace to rest of the court, the magistrate and no such palace shall be detained in custody beyond the said period without the authority of a magistrate. So beyond 24 hours, you can't detain any person, and you have to take permission from the magistrate. And the journey timing in this section is not included in these 24 hours. So nothing in clause 1 and 2 shall apply to a person who for the time being is an enemy alien, to any person who is arrested or detained under any law providing for preventive detention. So this is clause 1 and 2. This clause 1 and clause 2 is not apply on those persons who are dealing with the law providing for preventive detention. And the 4 is no law provided for preventive detention shall authorize the detention of a person for a longer period of the 3 months. So the law which are providing preventive detention, they can't detain a person for longer period than the 3 months. An advisory board consisting of persons who are or have been or qualified to be appointed as judge of High Court and reported before the expiration of said period of 3 months, and there is in its opinion sufficient cause for such detention. So in case you are detained any person for more than 3 months, then you have to take permission from the judge of High Court, and if they think that there are sufficient cause and there are sufficient reason in their opinion for such detention, then the person will detain for more period, provided that nothing in some clause shall authorize the detention of any person beyond the maximum period prescribed by any law made by any parliament. And the next is such person is detained in accordance with the provision of any law by the parliament under subclause A and B. And the next, the 5 clauses, when any person is detained in pursuance of an order made by any law providing for preventive detention, the authority making the order shall as soon as may be communicate to such person the grounds on which the order has been made and shall afford him the earliest opportunity for making a representation against the order. So in case of preventive detention also, this is mentioned that in case of preventive detention also, you have to communicate the reason, the grounds to the person which is detained and provide them opportunity for making a reasonable representation against the order of preventive detention. And the next is nothing in clause 5 shall require the authority making any such order as is referred to in that clause to disclose facts which such authority considers to be against the public interest to disclose. So it is up to the authority who are making that arrest that the information which may disturb the public order, so the information shall be concealed and not be disclosed for public interest. So the next clause is Parliament may by law prescribe the circumstances under which and the class or classes or cases in which a person may be detained for a period longer than the 3 months. So this is up to the Parliament. They can make law which provide the freedom to detain a person more than 3 months in case of the preventive detention, and without obtaining the opinion of advisory board. This is a discretionary law, that without obtaining the opinion of advisory board, which is constituted under the supervision of judges of High Court, the maximum period for which any person may be any class, any cases be detained under any law providing for preventive detention. The procedure to be followed by an advisory board in an inquiry under. So they are telling the procedure for the inquiry board in case if the board is constituted, but they are clearly mentioned that Parliament has the power and authority to make any law in which there is no need to obtain any permission from any advisory board and the person is detained for more than 3 months. So these are the 4 articles, Article 19, 20, 21, 22. Article 19 is related to the freedom the individual have and individuals enjoy about the freedom of speech, expression, peacefully assemble without arms, association, unions, and move freely throughout the territory of India, reside and settle in any part of the territory of India, and practice any profession. And their exception also, that in case of public order, in case of reasonable restriction can be imposed. And in the last in the interest of public order. And in the last clause G, the professional and technical qualifications are also added in the list of exceptions. In Article 20, first clause, it is clearly mentioned that a person shall be convicted to any offence or violation of any law, and the charge and the penalty which is imposed to that person is not greater than the offence and the penalty which might have been inflicted when the law is commissioned. And in the second, no person shall be punished twice for the same offence, and no person can be compelled to provide witness against himself. In Article 21, it is clearly mentioned that every person has the right to enjoy their life, and it is all about the personal liberty. And in 21A, there is a clause in which age 6 to 14 years are compulsory educated by the government. And in 22, there is a provision for protection against the arrest and detention in certain cases, which are explained further. So this information is enough for this CISF AC LDCE exam, and every colleague, every friend of mine should prepare for the exam very beautifully and very holistically, and at least one time they will go through these articles also, because these are a very minute part of our syllabus, and they can be helpful in understanding the legal structure and the legal mindset of our constitution makers. So one or twice these articles must be read before the examination, so that we are aware about the content and about the questions which could be framed by the examiners. So thank you so much, and in upcoming videos we are discussing more laws, more acts which are relevant for CISF AC LDC exam. So thank you so much everyone.